Hello, and welcome to So a Neighbor Asked, a monthly series from Mountain States Legal Foundation. This is a show where our attorneys answer your questions to help you understand the law, the Constitution, and the principles of liberty. I'm your host, Stanton Skrjanek. I'm the communications manager here at Mountain States. Before we begin, I want to share with everyone who we are as Mountain States. MSLF is a nonprofit public interest law firm dedicated to restoring those rights found in the Constitution and at zero legal cost to our clients. We are focused on protecting property rights, free speech and association, economic liberty, the right to keep and bear arms, and equality under the law. From our lovely headquarters in beautiful Colorado, we litigate crucial cases across the country and at every level. Trying to work to set precedent that is going to make a real difference in our country. Today, I am joined by Mountain State's very own attorneys, Joe Bingham, our senior attorney, and David McDonald, a longtime attorney here at the foundation. David, we have a very special guest with us today. Would you do the honors of introducing him for us, please?
Yes, thank you. So we're joined today by Jim Magagna, the Executive Vice President of the Wyoming Stock Growers Association. He's also served as the president of the American Sheep Industry Association and president of the National Public Lands Council. And he is, of course, a lifelong sheep rancher out in Wyoming. As someone who's been fighting for the rights of Western farmers and ranchers longer than the other three of us have been combined, I think, on this call, Jim knows better than most the forces threatening the Western way of life. And you don't spend that much time fighting the federal government out here without running into Mountain States Legal Foundation. So Jim and the other good folks, the Wyoming Stock Growers, have been longtime friends and allies of the foundation. We've been working together to defend the rights of farmers and ranchers against overzealous federal regulation on, God, I don't even know how many cases over the years, Jim, but it's been quite a few. So thank you so much for joining us today.
It's an honor and a privilege to be able to join you. So much of the work I do, unfortunately, has to be resolved in front of a judge in a courtroom. And we have relied on Mountain States Legal, certainly during my time here at the Wyoming Stock Growers Association, to represent many cases. And my first engagement with Mountain States Legal Foundation goes back to the very earliest days of the creation of the foundation.
Wow, way back in the 70s?
Way back in the 70s, yes. Incident with an issue that we're still dealing with today.
Jeez. Well, I'm sure we're going to be able to tackle a lot of those questions today, help our viewers understand. For our viewers online, before we really get into it, after we chat here for about a half hour or so, we're going to do our best to open up time to questions and answers. We probably won't be able to get to all of them, and we do apologize if we don't get to yours in particular, but we do have time for that at the end. You can do that. There's a little Q&A portal down at the bottom if you're here on Zoom with us. We do have Facebook open. If you're on Facebook watching, you can ask your questions in the comments. I'm monitoring those as well. So I guess with that, let's go ahead and get to our question. So a neighbor asked, how secure is our right to property? Is it really safe from the government? What can we do to protect it more? David, if you don't mind, I'd like to start with you. Help us set the terms. What do we mean by property, and what does it mean for our right to it to be secure?
So that is a doozy of a question. And I promised you before the call that I would not get too deep into Blackstone and all that nerdy stuff. But essentially, property is your right to things exclusively. It's what separates mine from yours at the absolute most simple of it. And that's, I think, obviously pretty clear to most people. It's pretty intuitive. When we think of property, we generally think of our things, our physical things, or our land, our homes that we own. But something that I think a lot of people don't really recognize is that, especially in the Anglo-American tradition, property tends to be a little bit broader than that. And that there are a million different ways that you can subdivide something that you own. So for example, I rent. I'm a renter. I'm not a homeowner. But what I do own is my lease. So while I can't make structural alterations to the property or anything, but I can choose who to exclude, who to admit in, including my landlord under certain conditions. And a lot of the work that we do and a lot of the work that Wyoming Stock Growers does kind of enters into the intersection of private property and public lands. So that's, I think, what we're talking about property here. A lot of times what we're talking about is this kind of subdivided idea of property where the United States might still hold deed to the land itself, but there are many people who have been sometimes out there for over a century who have very real property rights in that land, whether to ranch or to farm or to mine, that are no less real than your rights to be left alone in your own apartment.
Are you saying like their property develops because of their use of the land, or is that they have property rights to the land? I just want to make sure I get that clear.
Both. So sometimes rights are established by their use over a course of long custom and time and tradition. Otherwise, it's a way of more efficiently being able to use our resources. So more than one person can own different aspects of a single piece of property. So like I said, with the renting example, something we should all be familiar with, the landlord owns the actual building itself and takes rent from that and everything and has certain rights attached to that. But the landlord isn't allowed to enter the house, the apartment, without my permission. I own that. So I think so that we own different aspects of the same piece of property.
Right. So there's that kind of outlined contractual, like, so long as I have the lease, you can't just walk in whenever you want, even though you own the building. Okay.
Right. Exactly.
So that makes sense. So Joe, we kind of have this framework here. One of the cases that we've been in with, and I know that this is the case that we have with Jim and the stock growers is what we call Upper Green. I think it goes by another CBD v. Holland. I mean, how many CBD?
One of about a dozen.
Yeah, we have like 5
CBD Holland now. It changes names every time the relevant federal secretary changes.
Right. We call it Upper Green. So what is Upper Green?
Well, it's a case about ranchers' right to continue grazing on the federally owned public lands that they've been grazing on for over a century in the same way and taken care of. And it, I think it kind of highlights the ways that our caseload can be unique because we handle a lot of cases at the intersection of federal and public lands and private property that most kind of liberty-leaning organizations stay away from because it gets complicated. But I think you can tell from what David was talking about that he was talking about leases, and the government kind of sets the baseline rules for what you can do with your property. And people build their expectations around that in terms of what investments they make and improvements they make and what property they procure. But people can also contract around that and create different rules for their property arrangements, such as, a lease setting out the terms under which the landlord has a right to enter his property now that he has assigned most of the rights to that property to the lessee. And so the government for a long time has leased public land for grazing. It has a mandate to put those lands to a productive use. And so there are private landowners all around that area who have built their businesses and made their investments based on the government's promises. And so,
and not just their business, right? Like that's very important, but like their whole way of life. Like there's a whole subculture of Americana that's built around there.
Right, a whole culture, really, culture and an economy. And in Upper Green, environmentalists are trying to end grazing on federal lands in that area, which would actually destroy the value of the private property that our clients have in the area as well, because their use of that private property and the grazing cycle that they use to manage it depends on the availability of grazing on public lands.
So the government as landlord has a lease for ranchers. It's much more complex than anything we would have to deal with an apartment landlord. And then you've got third parties like environmental groups who want to try and reinterpret the lease so that it kicks the people out of their land. Jim, I know,
well, or cancel it,
or cancel it outright. Now, Jim, I know not only are you the executive vice president for the Stock Growers Association, but you're a rancher yourself. Have you ever help me understand, is Upper Green part of a pattern that you've seen, or is this kind of a novel attack on what's been going on?
Well, it's very much a part of a pattern. And I think there are a couple of principles that came out in David's and Joe's comments that are really important to understanding this. The first, most basic one is land ownership patterns in the Western United States. And the land is very split up, private land, state trust lands, federally managed lands, all intermingled. So the concept that I own a ranch and it's just a huge piece of private land is more the exception than the rule. So the interrelationship, and for myself and our ranchers throughout the West, we don't think of those land ownership boundaries. We think of a unit. We think how you best manage that unit to enhance the resources to take care of the livestock. And that's where we run into some of these conflicts. The other point that I think is really critical, David talked about the public lands and holding a lease on those lands. We go back and forth all the time, whether that lease is a property right in those lands, or as so many would like to say, it's a privilege. Mm-hmm. And I've had that argument numerous times throughout my career that, well, it's a privilege only in one sense, that it's granted by the government. It can be taken away by the government for abuse, for non-compliance with the regulations, and under certain proper procedures, it can be taken away or diminished if the resources can no longer support it. But so long as the rancher holds that lease, as far as we're concerned, it is a property right. It can be, has value, it can be sold, it can be transferred, as long as it's used for the purpose for which it was granted. So that's where this all begins. And as you've stated, and as Joe pointed out, in the case of the Upper Green, and they happen to be somewhat of a target today, but there's a different target every day from the environmental community that wants to remove livestock grazing off of the public lands. And the tools that they use in the case of the Upper Green are primarily the Endangered Species Act and the grizzly bear and previously the wolf. But in every case, they find some tool in federal regulations of some type that can impact private property rights and attempt to either encourage the agencies or through litigation force the agencies to impose and utilize that tool in a manner that is destructive of our industry.
So I'm kind of getting this idea here that things like grazing permits and leases, that they kind of fuse this concept of a privilege and an absolute right, that so long as the law grants you this privilege, it is your right to do with it within the lease's parameters, but it can't just be taken away willy-nilly, right? It is a contract still.
It is a contract that the federal agency is expected to honor. And there are processes for taking it away, as I've stated, but it can't just be taken away because we decided we don't want to issue it again without any substantive reasons to justify that. And so many of these leases or permits, for the most part, they're referred to as permits rather than leases, but they've extended to multiple 5 and 6 generations of the same family. So they have a stability both within the federal land management process and certainly a necessary stability and contribution to the integrity of the ranching operation.
Now, I've always been under the impression that ranchers are generally excellent stewards of land. They manage resources well so that it's for a long period of time, that they regrow, that it can sustain a herd, that it's well kept. So someone, maybe Joe here, since I know you're really tackling Upper Green specifically. And David, I know you've got a case that centers around these rights too. So I'm going to get back to you here. But Joe, help me understand this. If ranchers are the good stewards that they are, what environmental impact do these environmentalists just think ranchers are horrible for? I know Jim mentioned the Endangered Species Act. What's going on here?
Well, I think one difference is that ranchers tend to steward the land so that it will be at its best for people, for Americans. They understand that the earth is here for us and not the other way around. And environmentalists object to kind of prioritizing human beings over any particular animal species. And
kind of anti-humanism.
Right. So in this instance, the environmentalists have seen the grizzly bear population in the Yellowstone area recover and rebound very successfully alongside this grazing that's been ongoing for 100 years. But that's not enough for them because they want humans to kind of infinitely give way to an ever expanding grizzly bear population and just get out of the way.
They want to go back to the pre-European colony numbers, right? That unrealistic number way up there.
Right. So because the environmentalists prioritize the well-being of animals over humans, even when the species existence is not at risk, then they see any human activity that benefits humans at the expense of some animals as problematic.
I think it's important to remember too is that this isn't necessarily the ranchers versus the grizzly bear. The ranchers and the grizzly bear can coexist just fine. If anything, ranchers benefit more than anyone by a properly functioning ecosystem that's balanced with proper predators and prey and all that stuff together. The issue is that the environmentalists that are forcing these two groups, the bears and the ranchers, into conflict. That's not what we want. We want the ranchers and bears to both be able to coexist and to thrive on these lands. And it's that kind of loss of the multiple use mandate that the federal government has, that loss of that sense among the environmentalists and among some of their allies in the government that is really causing the problem here.
And Jim, this is something you can probably have more expertise in than I do, but people generally, I think, don't understand the scale of federal land ownership, especially in the West. But there is more than enough federal land to go around and be put to productive uses and also to conservation and recreation. And the law requires the federal government to do all those things. Environmentalists only want the government to be able to use its land for one thing, which is conservation. But can you talk at all, Jim, about the scale of federal land ownership in the West?
Well, it's huge. Right here in my own state of Wyoming, federal government controls and manages 48% of the land base. So that tells you what it is, and generally do a good job with that management to the extent that they're not constantly being challenged in court. One of the things that I think is important, and David talked earlier about, and you did, Stanton, about my backyard and my home, and there's a misperception with the public that doesn't understand the West, that the 5,000 acres that I may own as a part of my ranch of private land has the same property rights associated with it by our Constitution, by our laws, is the quarter of an acre that you may own that you have your home on in downtown Denver.
Right. And size doesn't diminish your constitutional protection.
It doesn't diminish my rights. And there tends to be a sense with many people, a lack of an understanding that somehow private property rights mean something less if you own large acreages of undeveloped land than if you own a very small acreage of developed land. And so that's one of the challenges we have is delivering that message to them. As far as the federal lands are concerned, in no case does grazing preclude other uses of the land. It's compatible with recreational use and with energy development on the land, both renewable and fossil fuel development. Where some conflict arises is because of the land ownership patterns that certain parcels of federal land may be surrounded by private land. And in protecting private property rights, you therefore have the impact of limiting, or in a few cases precluding, public access to that particular parcel of federal land. And there are some avenues to approach that, rather than litigation, through land exchanges, through easements of certain types, and the list can go on, and there's no one size fits all.
And if I can flag one other thing that I think a lot of people, at least kind of Eastern Yankees like me, fail to appreciate culturally and economically about the West, is the extent to which so many of these farms and ranches are multi-generational family operations. I mean, one important reason that we have private property and recognize private property rights is because we want to incentivize the people who own property or who are in charge of it to make the best use of it and take good care of it. I think all of our clients in Upper Green are family operations. All of our ranching clients are family operations that have been in the area for about a century. And so, you know, nobody cares more about sustainability than somebody who owns land and wants to pass it down to his children. He's not going to try and use it up and destroy it and strip mine it because he wants his family to inherit this property. Which is why, of course, we have so much complicated law about inheritance of property rights, because we want people to think past the next 40 years.
Yeah, and talk about the idea that if you own a piece of property, you're more likely to take care of it than if everybody owns it. Because if everybody owns it, that idea of public ownership, then no one really owns that. There's a term for that. What's that called?
That's the tragedy of the commons.
That's tragedy of the commons, exactly.
Yeah, it's a very early economic parable about the public square, and when everybody owns the public square and grazes their animals there, then pretty soon there's no place there to graze animals because nobody has an incentive to moderation or sustainability. Whereas when one person owns that land, even if he makes it available to other people to graze, he has every incentive to make sure that it's not overgrazed and continues to be sustainable.
So I want to, and the crazy thing is the power of this concept of private property and the incentives it creates for people who own it is that it's true even for people who are strip mining the land. So there are a lot of people who own mining operations stuff who are making responsible use of those resources, and that's kind of our client in the Rayco v. Howland, another Howland case. We represent a small mining operation out in the Mojave Desert. And one of the first things that our client said to me when we went out to visit, we went out to the old mine. They'd been kicked off by the government. They've been out there, kicked off for about 20 years now. And you look and there's trash everywhere. All the structures are shot up. There's shotgun shells laying everywhere. There's graffiti. There's trash. There's all kinds of horrible detritus everywhere. And our client, Monty, looks over to me and says, they kicked us out because they wanted this for a natural preserve. Like, does this look preserved to you?
But thank God there's no mining, right?
Yeah. Because the only difference, if you go out there and look and see, okay, look at a picture of it from 1997, you look at a picture of it now. The only difference is now there's a bunch of stuff everywhere. There's a bunch of worthless, rusted out metal hulks and trash and beer bottles and stuff, where once there was a thriving business and a nice little family home that was kept pleasantly. And when there were people causing problems or fires or anything, you know who called the BLM? It was Monty or Emerson Ray. It were these private property owners are the ones who are the only ones who have any sort of incentive, or a lot of times the only ones who even are around to manage it. Because again, these are vast, wide open spaces. There's not necessarily the ability for the federal government to pay attention to all this, even if it wants to.
I think an important point there, and certainly we see it with ranching, is we don't claim to own the public lands as ranchers, but we take ownership responsibility for the management of those lands because we depend on them year after year after year, and our kids and our grandkids depend on them for the sustainability of our ranching operations. So we treat those with the same sense of ownership responsibility as the lands that we legally own.
And it's really kind of frustrating because we all have this understanding of how vital that ranchers are, that miners are to this, to that kind of sustainability over a long period of time, and how essential that they are to to feeding the world, to providing the necessary ingredients for industry. And you almost got to think, man, how could anyone think that shutting these people down is a good idea? And I almost hate to be cynical, but Joe, you made that point earlier on. They can only have a pro non-human nature view of the world, that everything at the expense of any sense of comfort, any sense of progress. It's like an anti-progress agenda. It's very, very.
I mean, it's anti-human and anti-civilization. I mean, one, except when they're putting their money where their mouth is. I mean, I have a lot more respect for environmentalists who buy land to conserve the way they want to conserve it, although that can be problematic depending on the situation and the strategy. But at least the incentives remain correct, so that people have every incentive to continue putting the land to kind of its most productive and highest value use. Whether that, I mean, and sometimes that will be for the short term. I mean, there is some land that should be strip mined, as David was pointing out, but generally it'll be for the longer term.
Yeah. One of the laws that we've been talking about, and I know there's a couple of things that talk about in here. We talk a lot about the Endangered Species Act. And we've chatted about that on our website from time to time, and I know it's at the heart of Upper Green, but it's also at the heart of another Wyoming stock growers case. I don't know if Jim or David, if one of you have familiarity with this. Is this the jumping mouse case? Does that sound familiar?
Certainly is familiar to me. It's one we were involved in, 10, 12 years ago. The Preble's meadow jumping mouse, which is the particularly subspecies that's found in northern Colorado and into southeastern Wyoming, I believe slightly into western Nebraska as well. And that one was petitioned for listing. We went through quite a lengthy process there, as well as some litigation. And we're finally successful in keeping it off the endangered species list as an endangered species. I believe it was listed as threatened. But a good example of that, how it impacted our ranching community, is that in this particular state, these rangelands and meadowlands that are very dependent upon irrigation during the summer season of the year, which means irrigation ditches to carry that supply of water. Well, one of the constraints that came with the Preble's meadow jumping mouse is that you couldn't disturb any of the forage that was growing in irrigation ditches, because that was habitat for those mice other than when the water was there. And if you don't clear irrigation ditches, they become closed up, and pretty soon you don't get the water anymore. And so that was just one example of where an Endangered Species Act action basically took away a private property right to use a water right that you hold legitimately under the laws of the state of Wyoming, and apply that water to the ground on which it's been authorized to be placed. So endangered species came in there. I might just briefly mention sort of the opposite side of an endangered species case, and that's the black-footed ferret, which was long deemed to be extinct until a rancher's dog in Meeteetse, Wyoming, discovered a black-footed ferret. And because of the rancher reporting that and his dog, they found the only remaining colony of those ferrets. They were able to save some of those, take them to a place where they could, in a closed atmosphere, raise ferrets. And now the process is putting those ferrets back out on the land and reestablishing a species that would have become extinct if it weren't for the commitment of that landowner. frankly, for the work of his dog.
And I'd note that I think a common thread among people who don't appreciate private property rights or understand why they're important and benefit society as well as the individuals who own property is that they don't understand kind of the most basic truth of economics, which is that people respond to incentives, which helps explain why the Endangered Species Act is constructed in such a incredibly incompetent way to create terrible incentives, the opposite of the ones it intends to inspire. I mean, Jim just talked about the rancher reporting the animal that his dog found that was previously thought to be extinct. I mean, that's a heroically virtuous rancher, because a selfish and smart rancher would have killed it as soon as he saw it and killed every one of them that he could find on his property, because the last thing you want is to have a species that's on your property be listed as endangered, and your use of your property be constrained by its presence there.
So far from the Endangered Species Act being a tool of the public to protect other species, it becomes a weapon by which you want to avoid it being wielded ever, which defeats the purpose of the policy.
I mean, it's a weapon against property owners that gives property owners every incentive to avoid caring for any species on their property that could later be listed or as threatened or endangered.
So I want to ask this question, since we've covered a lot about mining with the rays, we touched on Upper Green and the jumping mouse cases. What do all these cases say about our right to property? Is it generally being ignored? Is it doing just fine? Is it on the verge of being just eradicated? Like what's the status of our right to use our things, to control what is ours? What's the status of that?
Yeah, so to borrow language from the ESA, I'd say it's threatened. I don't think private property rights are endangered in the United States. I don't think we're under any real risk of a purging of the kulaks anytime soon or anything like that. But what we see here across all these different industries and areas is a theme of Leviathan nibbling around at the edges, taking bits and pieces here whenever they can. It's fairly rare where you see the government just outright seize property anymore. That's very unpopular. It's also very expensive. They tend not to want to do it. You see more and more commonly is this kind of death by 1,000 cuts of regulation. Is you won't be denied a grazing permit. Your cattle might not be taken away from you, but next time your permit is up for re-up, well, you get half of it now. Or there's restrictions that on the length of grass or any number of things, or about ditches. You're running the mine, things are going great. Only you learn that you have to file a certain application with the Forest Service. They refuse to accept anything except for the form that the BLM gives you, but the BLM refuses to answer your calls, so eventually you get kicked off your mine. It's these little tiny things that most of us aren't even aware of if we're not dealing with the bureaucracy day in and day out. And it's that kind of death by 1,000 cuts that I think is the real threat here.
So this is what people are talking about when they say they hate red tape. It's not that it hampers production and innovation, though it does. It's because it does this. It creates that framework of denying property. Jim, I saw you shaking your head when David was talking. That death by 1,000 cuts, it sounds like you're pretty familiar with it.
Well, certainly, and it comes in so many forms. I mean, as a rancher, at one time you're dealing with federal land agencies, BLM or Forest Service, and your property, your ability to utilize your permits. You load on top of that the Endangered Species Act and the many ways and the incredible number of species that are petitioned for listing, and even just a petition to list that may sit idle for a couple of years until the Fish and Wildlife Service can get around to addressing it. It puts a cloud over your use of that land. Then you add on to that your water rights and the waters of the U.S. battle that's going on right now. And these just pile up one after another to where frankly, it's hard for a rancher not to say, maybe I can last this a few more years, but I don't see a future for my kids and my grandkids on this ranch. And if they force to give that up, the other thing that so often happens, and the Upper Green is a good example, as Joe pointed out, if I can no longer graze my cattle on the Forest Service, then my ranching operation's not viable. And the only alternative that remains for me for my private land, which is often the most productive lands, the meadow lands, that is to subdivide it and sell it for home sites or something. So not only does the rancher lose, perhaps not financially, but in terms of a lifestyle and a future, but the public loses in
Suburban
terms of
tract homes, famously great for the environment.
wildlife and loss of places for recreation and hunting and fishing.
David, what did you just say there?
Oh, these other suburban tract homes are famously great for the environment.
No, yeah.
I think Milton Friedman pointed out that, and I'm sure others have too, that the most important thing about property rules and under the rule of law isn't necessarily exactly what the rules are. It's that the rules are predictable so that people can work around them and plan around them and contract around them. And anytime the federal government does something arbitrary, or the environmentalists go to court to force the government to do something arbitrary or unreasonable, it undermines that predictability, which is really the central and most important feature of our property rights under American rule of law.
Absolutely. I have one more question for you all here. Before I do, I just want to remind everyone who's watching that if you have a question, do please put it in the Q&A portal down at the bottom. Don't use, there's a comment section too. I won't be able to get to that, but if you use the Q&A button, I should be able to answer your questions pretty well. And of course, comments on Facebook. So before we get to Q&A, I've generally just kind of one more broad question. We've talked a lot about the cases that we're currently in, but on the whole, what's being done to make sure that this threatened right that you described, David, what's being done to make it more secure? What is MSLF doing? What kind of litigation is happening? And what is the Wyoming Stock Growers doing on its daily basis to protect this as well?
So I'm happy to take the first crack at that. So obviously, I'm pretty proud of the work the Mountain States is doing in this regard. So we're litigating both kind of on the plaintiff side on behalf of small operators, like members of the Wyoming Stock Growers, like the Ray family, like the Longwell family, people who are having their property rights kind of nibbled around the edges, or rather gobbled up. I guess they happen to be the edge cases. Helping those people fight against the government, kind of setting precedent there. We also do a lot of work, and I think Joe can probably talk a little bit more about this, is that we intervene a lot on behalf of farmers and ranchers and miners and other such people, a lot of times to defend on behalf of the federal government, which is a weird thing coming from us. But we do that a lot just because oftentimes you can't necessarily count on the feds to put the good arguments out there. So we do a lot of different types of litigation to help it out there. We try to do a little bit of outreach, like in education like this when we can. And then there's other organizations like stock growers, like other litigation outfits, other think tanks that are doing a lot of work. But so I'm sure Jim and Joe both have a lot to say about that as well.
Yeah, I think we intervene on all sides in different kinds of cases for good reason. In Upper Green, we intervened on the side of the federal government because it made the right decision and was being sued for that by people trying to force it into the wrong decision. In another case we just launched recently that we call the Idaho Stockwater case, we intervened successfully on the side of the state of Idaho against the federal government because the federal government is suing and trying to subvert Idaho's state property law to which it's subject, so that it can hold on to water rights that it's not entitled to under state law that our clients are entitled to. And so with the way our court system works, every time the government makes a decision, somebody's going to sue. And when they make a bad decision, we try to be the person suing And when they make a good decision, then we try to make sure it stands.
For us at Wyoming Stock Growers, we really have at least a two-phased approach to this. The litigation component, which has been talked about here this morning, and most often we are involved in litigation either as an intervener or filing amicus briefs. In my recollection, my 25 years here, I think only in 2 cases did we ever file litigation. That we're not litigation oriented. We're oriented to finding solutions short of litigation. Right. But the other component is on the legislative front. And fortunately, here in Wyoming, we've been very successful with our Wyoming legislature and with our state government in enhancing our private property rights laws, certainly protect us from a lot of private litigation. There's a limit to how far state law can protect us from the actions of the federal government in here, but even there, it's some benefit to it. And we work on these issues with Congress. Unfortunately, getting these types of improvements through Congress in recent years has been sort of appears to be a hopeless struggle, but we will not relent in our desire to push for issues like that, to continue to protect private property rights and the culture and the history and the future of ranching, and not just in Wyoming, but throughout the West.
Yeah, I've heard dealing with Congress is like Sisyphus rolling his boulder up the hill over and over and over again. That's excellent. We have actually quite a few questions here, and I think there's some really grand ones. So again, I apologize if I don't get to your question in particular, but I do value them. There's one question I think is really pertinent to what we've been talking about with these cases. This comes from James. How or why do environmental groups have standing to sue? Like where do they get their authority to bring these cases? That's a good question. What's their harm? I have no idea. So Joe, David, want to take one of these on?
I mean, in some ways, an extremely complicated question that it relates to probably the single most litigated constitutional issue throughout federal history, especially the last 50 years or so, is that the Constitution only gives federal courts the authority to hear something that's a case or controversy. And so if you want to bring a suit, you have to show that you will actually be impacted by the outcome of the suit. And the Supreme Court's gone back and forth, kind of making that harder and easier in different instances. But right now, usually environmentalists can get standing to challenge a federal land use decision just by saying that they like to go to that land and enjoy watching whatever species they're contending is put at risk. And thankfully, the Supreme Court has kind of put some limits on that. So it's not just completely out of control. Anybody can sue about anything the way that it was maybe under the Warren Court and for a while after that. But that is a really complicated legal issue, actually.
I think another really important component of that, it's not the direct legal issue, but that is the ability that these environmental groups and that have mastered of filing these cases and then getting their legal fees paid by we, the taxpayers. The Equal Access to Justice Act and a couple of other federal laws that were intended to say if you're a poor person and you're being injured by an action of the federal government, a federal agency, you need to be able to pursue a remedy and be able to afford it so you can get your legal fees reimbursed. Well, they have perfected the use of that. So frankly and honestly, every lawsuit that they win or they settle funds the next lawsuit that they file. And it's just a never-ending process. And we've been trying on the congressional front for years now to get some changes made to some of those laws. So it's not a free ride to file litigation. To this point, have been unsuccessful with that. Incidentally, in the only case that I can recall that we ever sought to receive our legal fees back when we worked with a private law firm as opposed to someone like Mountain States, we were denied. So that's why on our side, we're so dependent on Mountain States Legal and other entities like that, public interest law firms, to represent us, because we don't have the dollars to do it, and we've not been successful in getting our legal fees paid by the taxpayers, as some of those groups appear to be.
And unfortunately, when there's an administration like the current one that's on the wrong side of these issues, and it gets sued for making a good decision, then it will all too often settle the case and make a big payment under the Equal Access to Justice Act to the environmentalists to incentivize them doing the same thing again.
The sue and settle tactic. I know that we've talked about that a little bit.
Which is a good reason for us to be intervening, because then when the government won't stand up for its decision, we can.
Absolutely. I have another question here. David, I'm going to field this one to you because I know you like this question. It's more something of a history question. I want to encourage you to be within a 2 to 3 minute window here if you can make it. Okay. Olga asks, I'm pretty new to these issues. How did the states lose control over so much land in the West? How did the federal government get all that?
Yeah, so that's actually a really long and interesting story. I encourage you, anyone listening, our former president, William Perry Penley, he probably would hate me for bringing this up. He got a lot of crap for it during his confirmation hearings. But he wrote an excellent National Review op-ed about this about a decade ago. I encourage everyone to go read it. But the issue is essentially that we don't have a lot of these issues on the East Coast. On the East Coast, it's mostly private land and state land, because that was mostly settled in the kind of the early first half of the nation's history. The issue is once you get past kind of the Mississippi River, is a couple things happened. One was that this land was acquired in massive quantities all at once. It was the Louisiana Purchase and it was the Mexican-American Cession, mostly. It's almost the entirety of the West of those two things. So you have a lot of land going at the same time, and a lot of that land in the interior, especially when value for land was primarily for farming purposes, a lot of it was of marginal value because it was difficult to get to for water. It was difficult to get to, just literally difficult to get to in the vast interiors of the United States. So the federal government ended up taking on all this land and holding it. And originally it was supposed to hold it just to be able to manage it and disperse it. So that's why the Bureau of Land Management was originally, it was not the Land Management Office. It was, I forget the name, it was the General Survey Office and the Grazing Office. But originally this was all supposed to be held for the eventual sale to homesteaders or to industry, miners, ranchers, that sort of thing. And anything that wasn't given over to that would be mostly turned over to the states. That's how it had been in the past. That's how it was expected. But it never really turned out like that for a wide variety of reasons that are far too complicated to get into now. But essentially, in the middle of the century, the federal government decided that its mission in managing the land changed from ensuring Americans could use it how they see fit to protecting it from the American people for the wildlife and stuff. So that changed the priorities. It caused them to be a lot less interested in giving it up to private individuals or to the states. Although, ironically, I think a lot of the conservation aspects would have been better served had it been turned over to private people or to the states for all the reasons we've already talked about.
Yeah, the paternalistic mentality of the federal government. Go figure. Excellent. Very good. That was a very great answer. I appreciate that. Thank you. I have another question, and we've touched on this a little bit, Joe, with our Idaho Stockwater case. This comes from Victoria. Can you expand a little bit about the current water rights issues that are impacting ranchers and farmers? Yeah, I'll go with that. The whole question of water rights being a property right too.
Well, I'll touch on a couple things. There are all kinds of issues around that, and that's again, Jim's had expertise on this since before I was born. So, I'm in our Idaho Stockwater case that I mentioned. It concerns the right to water your stock on federal grazing allotments, and the government's trying to take those watering rights normally the government owns that land, but the person who's using the water rights owns the right to water their stock there. The government doesn't own that because it doesn't run cattle, and it doesn't. You have to use water rights to maintain them. So there, the government is trying to take those rights away so that it'll have more leverage over the grazing permittees, because even if it can't threaten to tell the rancher, I'm going to take your grazing permit away, even though you're complying, they might be able to say, well, you can graze here, but you can't let your stock drink any water, which is effectively the same as taking away the grazing permit. Another major issue is the federal government's definition of waters of the U.S. under the Clean Water Act, because it makes all kinds of development activities incredibly expensive if the federal government thinks, or even might think, that some water on your land falls within that definition. And the current administration is, of course, pushing for a broader definition. It's already way too broad and captures a lot of land that was never intended by Congress. But the Supreme Court is about to update its analysis of what waters of the United States means under the Clean Water Act, and hopefully we're going to get some more clarity and better law. Jim, are there any other major water issues right now that you want to mention?
I think those are the primary ones, and for us, we've not had huge problems to date with the water rights for livestock on federal lands. Although with our water along Wyoming is slightly different than, say, Idaho's, and it's worked relatively well. But the issue of that any place that have a little pond of water or a little bit of water that flows even ephemerally just for a month or so, that might be on my land, on my private land even, and under some interpretation we've had in the past, and under what we see coming from the current administration today, I have to be reluctant to do anything that disturbs that, because I may be challenged again through litigation under the Waters of the United States rule.
Yeah, there was a case, I think it was Foster v. Vilsack, I think it was called, about 7 years ago, that I wrote a brief on, where it was Prairie Potholes. Anyone who's not familiar, is kind of a geographic feature. Essentially, it's a depression in your land. That as long as one of those depressions in your land sometimes fills with some amount of water once or twice a year, that's waters of the United States. You can't touch it. You can't farm that. You can't do anything with it. So when we're talking about waters of the United States here, that's the kind of broadness we're talking about.
Perfect. I have one more audience question, and then I have our closing aspect. So again, to everyone who asked the question, thank you very much. If I didn't get to yours, I apologize, but I do appreciate you asking. So Dave, I'll direct this one again back to you. This is from Carrie Ray from our RACO case. And she asks, what are your thoughts on whether or not the government has not just a bureaucratic angle, but an actual agenda on mineral content? That it's not just about environmental aspects, but about government controlling precious minerals and things like lithium, rare earth, things like that. It's not just about protecting the environment, but about controlling resources. Can you elaborate what your thoughts on an agenda versus one or the other?
Yeah, and this is something that comes up a lot as a theme in a lot of our cases, and it's difficult whenever you're talking about intent. It's difficult to say something definitively. It's hard to look into the deepest hearts of every federal bureaucrat. But I think we do see exactly what you were saying is oftentimes a desire for control masquerading as a desire for conservation. We see that specifically in the Ray case, where we see that there, and we see that in a lot of our cases where what's known as inholders, is either private property owners or people who have been grandfathered in under old systems who are on federal land for whatever reason. The regulators there tend to not like them. They joined the Forest Service or the Fish and Wildlife Service of the BLM because they want to wear the Smokey the Bear hat and wander around and smell the flowers and all that. And it really bothers them that there are people making money out here. There's people besmirching their park. And you really do get a strong sense of that from a lot of the people out there. And it's oftentimes it seems it's more so than kind of any actual protection goals for the environment, more of a, we just don't like you, we want you out, you don't fit with the vibe that we got going here now. You hear a lot of talk about kind of, why won't you get with the program? Oh, you dinosaurs, we don't need this anymore. Don't you know we do all our mining in China now? Let's what are we doing? And I think you see a lot of that, a lot of kind of selfish aesthetic reasons that kind of masquerade as high-mindedness.
All right. I think that's a great way to answer that question. So we're closing down. We're down to the last couple of minutes of our hour. So I want to let you, each of you, kind of give your last kind of closing comments or ideas before we close out our show. And you know what, Jim, why don't you start first? You're our guest.
Well, one point that I would make, that because of all this discussion, we've been focused on federal government and federal agencies. Our experience, we do have a lot of very good people in these agencies at the local levels that want to do the right thing. And what I've experienced over the years is that so often they're precluded from doing the right thing, either because of one, leadership higher up the chain in Washington, D.C. that says, no, you can't do this, or two, and so often the answer is from a local administrator of land or water rights or that. I agree with you, but I can't do that because I'll get sued. And the extent to which the threat of litigation from the other side drives the management of these resources is just incredible. And to me, it points to the need for us to do all we can working with entities like Mountain States Legal to drive the management of these lands through, unfortunately, through litigation, but through litigation that the users of the land and the true caretakers of the land pursue, rather than just litigation that's brought by our opponents.
Yeah. So you wouldn't expect to hear this from our webinars, but the problem is systemic. I think what Jim said is 100% true, is that there are a lot of really good people who are working in these agencies that really are trying their best. And a lot of the environmentalists, that they're not evil people. They see the world differently than we do. Maybe they may not just be as respectful towards us as we would like. But I think that is issues, is a lot of this is systemic. And as much as we want to find individual heroes and villains, well, I think there's plenty of heroes, but a lot of times there isn't necessarily a hero so much as a sclerotic system that is not well optimized to provide good incentives for people. It's kind of conglomerated over the years in ways that no one ever really intended. And a lot of this is really kind of fighting against the structures of how things are built up with the system of laws and regulations. And it's not necessarily about people being evil or wrong or wanting to do harm so much as we're trying to inform people so that they know what's going on, and also kind of align these incentives and make sure that the few bad actors have limited reach.
Very good. I can't add on to great comments there. Otherwise, I diminish their greatness. Joe, floor is yours.
Well, I guess two things. One is, they've kind of touched on the extent to which the federal government is more afraid of environmentalists than they are of pro-liberty organizations. And that's just because there's a vast disparity in funding. The environmentalist organizations and progressive litigation groups are so much better funded. And the only way that the government's calculation about who they're more afraid of is ever going to change is if people continue to support Mountain States and our allied organizations in these fights. We would like to see a federal government that is telling the environmentalists, I'm sorry, we can't do that because we get sued by Mountain States. The other thing I would close with is just a thank you to Jim. Like we said, he's been working with Mountain States since I think before any of the rest of us were born. And he is just still one of our most valuable partners, and brings us the best cases, and keeps us posted on what's going on the ground in these rural areas and with ranchers. And we really appreciate him being here today, and also just his how much he's given to Mountain States in general.
I think that's a beautiful way to end it. Absolutely. Thank you, Jim, for joining us today as well. I know we always value your expertise, your input. And thank you all for joining us on this episode of So a Neighbor Asked. Within a week, we should have this episode uploaded to YouTube. So you should be able to go back, share it with your friends and your family and your neighbors, and have these conversations over and over again for as long as you can. In the meantime, you can keep up to date with Mountain States' work at our website, mslegal.org. You can follow us at Twitter at MSLF, Instagram at Mountain States Legal, and of course here on Facebook. Thank you to our panelists, and again, especially to Jim, and to all our viewers. We'll see you next month. Bye-bye.